with Mo. Good morning, everybody, and welcome to another episode of Monday Morning with Mo. I am Mo DeWitt, and you'll notice our location is a little different this week. I am on vacation, but hey, that doesn't mean that I can't still answer your legal questions. So, as always, if you have any legal questions, give us a call, 407-536-6737, or shoot us an email, ask@dewitlaw.com. We're broadcasting today from the lovely Bahamas, so glad you could join us. Well, not join us on vacation, but join us for the show. So anyways, first up this morning, we got William. William says, my stepson was just involved in a car accident and has neck and back pain. He was rear-ended by a car, and the other driver was ticketed. Okay, so he wasn't at fault. That's good. He doesn't want to go to the doctor because he's afraid if he calls a lawyer or goes to the doctors, his rates will increase, his insurance rates, I assume you're talking about. All right, so under Florida law, the insurance company cannot renew your policy if you're not at fault or if they're not substantially at fault, unless you've had 3 or more accidents within a 3-year period. So if you've had, if this is his 5th accident within a 3-year period, they could potentially drop him, even if he was at fault or not at fault for any of those accidents. However, if you had 2 accidents within a 2-year period and they drop you or try to increase your rates, they would be violating Florida law for that. So, shorter answer is, assuming that he hasn't had 3 accidents within a 3-year period, his rates won't go up as long as he was not at fault. And it sounds like this case he wasn't. So, as always, I certainly recommend getting checked out by a doctor. If you're experiencing pain immediately after an accident, typically it's only going to get worse, not better. So you want to make sure that you get checked out by a doctor as soon as possible, because you want to make sure, A, you're documenting all those injuries, you're getting treatment for those injuries. I've had cases before where people had minor pain after an accident and they had back injuries years down the road. And they didn't really do anything about it. And at that point in time, if you're waiting years to get treatment, there's really not a whole lot that you can do at that point. Actually, one person I'm thinking of had to have a disc replacement, and it was really caused by the car accident. But they said, I'm tough. It's just a little back pain, won't be a big deal. And years down the road, they had to get surgery because of that. So definitely want to get checked out as soon as possible. Make sure there's nothing serious going on there. Again, as long as you don't have 3 accidents within a 3-year period, you should be good. But if you do, then your insurance company could drop you, or your rates could go up. Got a side by side driving by there. All right, next up this morning we got Shirley. All right. Shirley is currently represented by another attorney. She's happy with them. That's great. But heard that she can get a settlement in 30 days and wanted to know if this is accurate. All right, so if anyone's telling you that they can get you a settlement within 30 days or they can guarantee that they'll get you paid X amount of dollars, they're just lying to you. I mean, from a legal standpoint, really no attorney in Florida is allowed to make a guarantee of any kind like that. So, we can't guarantee what the outcome of a case is going to be because we don't know. I can tell you based on my experience handling other cases what I think it might be, but it's very difficult for me to say, hey, you're absolutely going to get this amount, or that we're absolutely going to be able to settle it within a certain amount of days, because unless the injuries are really just catastrophic, typically you're going to want to reach what we call MMI, or maximum medical improvement. So you're going to want to wait till you get to the point where you're the best you're possibly going to be before you settle that claim. Because let's say you're going through treatment, you're getting checked out by doctors. Usually you're going to take the path of least resistance first. So you may try chiropractic care. You may try rehabilitative therapy, before you get to surgery. But let's say the rehab care doesn't work and the doctor said, hey, your only choice left to try to get better at this point is surgery. Well, if you settle that case before you do the surgery and you still need the surgery, it's going to be worth a lot less than if you settle it after you get the surgery. I'm not saying that you should get surgery if it's not necessary. You only want to do surgery if it's absolutely necessary. I think surgery is a last resort, personally. But you have to wait until you reach that maximum medical improvement to settle the case so that you know what your future damages are going to be and what your current damages are. So anyone who's saying, hey, I can absolutely get your case settled within 30 days, you know, promising a time frame is very speculative. And like I said, unless it's really catastrophic injuries with low insurance limits, promising any sort of time frame or payout amount, they're probably just lying to you. They're just trying to get you to sign up quickly. Probably not a above the board shop, if I had to say so. So I'd probably stick with your current attorney, Shirley, and and go from there. And hopefully they're going to take good care of you. All right, as always, get a little fly there. As always, you got any legal questions, shoot us an email, ask@dewhittlaw.com, or you can give us a call, 407-536-6737. Leave those voicemails there, and we'll answer them on the show next Monday morning or any other Monday morning. So, as you know, we're always here Monday morning, 8 a.m. to answer your legal questions, even when we're on vacation. So, next up, we got Michael. Michael says, my wife and I have been separated for several years now. We are on good terms, but have not yet filed for divorce. I'm in the process of purchasing a new home, and the title company says that I need a legal separation agreement in order to close on the home. Are you able to draft a legal separation agreement for me? All right, Michael. So I'm assuming this is Florida. So in Florida, there's no such thing as a legal separation agreement. So while you guys may be separated, you may have now lived together for a number of years now. We don't recognize legal separation, meaning it's not like a divorce or anything like that. In order to get divorced, you actually have to file for divorce. So what the title company is telling you is somewhat off, but what I think they mean is that your wife is going to need to acknowledge the mortgage. So in Florida, under our homestead laws, basically, if you buy a house as your primary residence, your wife has to acknowledge the mortgage because you're not supposed to be able to go out and take out a mortgage without your spouse's knowledge unless it's an investment loan, because our homestead laws protect that if it's your primary residence. So, first of all, even though you're separated, your spouse is still going to have to sign that mortgage. But along with that, and this may be what the title company means here, is you're going to want to have her sign a waiver in her interest in the property. So that if you do ever get divorced and things go south, that she's not coming back and claiming that she's owed part of the equity in the property. So, it's a pretty simple agreement. You just basically say, hey, the property's, non-marital property. It's essentially like a post-nuptial agreement. Property is non-marital property. It's my property. Um, you're going to waive any interest in the property. In exchange, you're not going to be responsible for any of the debt either. So you have her sign that. You have her sign the mortgage. Assuming she's agreeable to signing those things, you should be good to go and there shouldn't be any issue. But you want to make sure you do that quickly because obviously there's time frames on closings. There can be issues that arise, and you want to make sure that she's going to be good to sign off on that, so that you don't have any issue down the road. Because otherwise, quite frankly, the title company can't close the loan without her signing the mortgage and acknowledging the mortgage, unless it's an investment loan. So best of luck with that, Michael, and we're happy to help you. So I'm sure we probably already gave you a call back or shot you an email, but always happy to help people if they have those kinds of issues. So if you have any issues, shoot us an email, ask@dewhittlaw.com. All right, last but certainly not least this morning, we have Jeremy. Jeremy says, I purchased a home with my ex-girlfriend before we broke up. We were both listed on the title and the mortgage, but I paid the down payment and always paid the mortgage. We broke up 6 months ago after I caught her sleeping with my friend. Sorry about that, Jeremy. I told her to move out and we haven't spoken since. Now she is suing me to partition the property, claiming she wants half the equity and wants me to pay her attorney's fees. I don't want to pay her a damn dime. What do I do? All right. So, you guys, when you own a home together like that, you're what we call tenants in common. So, if you're not married or if you're not joint tenants with the right of survivorship, you're what we call tenants in common. And so, basically, under common law, it's that the tenants in common contribute equally to the property. So, she's supposed to pay half, and you're supposed to pay half. And that's essentially the presumption. However, if she hasn't paid her proportionate share of the expenses, for the mortgage payments, the taxes, necessary repairs, things like that, then you can be entitled to a credit for those. So even though she's suing you for partition, what you need to go back and do is gather all the payments you made, gather the down payment you made, gather any proof of taxes, which may be paid through your mortgage, um, gather any proof of repairs, any credits that you are entitled to for that. And then when you respond back to that lawsuit, basically you have to say, hey, there's no real argument against partition, against selling the property. And also part of that includes that you could buy her out of the property, but that you're entitled to a credit for all these things. And so really that's probably going to eliminate, any equity in the property that she would have because you've paid for basically everything in the property, I'm guessing, unless the property is really just increased in value, passively an astronomical amount. So you want to go ahead and start gathering that information because you're going to need it for the partition action. As far as the attorney's fees, usually attorney's fees are allowed in partition actions, in proportion to the well, the best way to put this, basically proportionately to how well they assisted in getting the home partitioned, if that makes sense. So if the attorneys are actually assisting in getting that house sold, they are entitled to attorney's fees, which can be taken out of the sale proceeds of the property, assuming that you sell it. But I will give you kind of, my 2 cents on that is typically you want to try to resolve these cases as quickly as possible with as little attorney's fees as possible, because the attorney's fees can really eat up the any profit that would be made from selling the property pretty quickly. And like I said, there's really no argument against partitioning the property. So if you can reach some sort of agreement early on without spending a bunch of money in attorney's fees, that's always the best, because at the end of the day, some of these cases just end up in arguments over the attorney's fees themselves rather than the actual, credits and what the parties are due. They start getting into these arguments over what the attorneys are due, and that's obviously not best for the client. So if you can, try to resolve it as quickly as possible so that you can try to avoid racking up those attorney's fees. All right, I thought Jeremy was last, but I guess we have one more here. All right, last one this morning is from Kara. Kara says, if I was divorced in Wisconsin but moved to Florida prior to the final divorce date of August 2020, do I have to pay federal taxes on my alimony? Would I've had to have my divorce in Florida for the new alimony tax law to apply to me? All right, so I think you're referring to the tax law that went into place, I think it was the beginning of 2019, maybe it was 2018 at this point, that basically made alimony where it has to be paid with after-tax dollars and is no longer taxable as income to the recipient. So that was a federal law. It doesn't matter what state you're in, as long as you were divorced after that date, and it's either January 1st of 2019 or 2018, if I remember correctly. You were obviously divorced in August of 2020, based on your email here, so you'd be well after that date. So currently, which you would be governed under the current law, doesn't matter what state you were divorced in. If you're a spouse paying alimony, you're paying it with after-tax dollars. So it used to be an off-the-top deduction, meaning you could pay it with pre-tax dollars. It's an off-the-top deduction for you, and the spouse who is receiving it would have to pay income on it, just like it was taxable income. They got rid of all that. Now alimony is paid with after-tax dollars, and if you're receiving alimony, you don't have to pay taxes on it anymore. It's not income to you, taxable income to you. So, as always, thank you guys for joining us. We'll be back next Monday morning, probably from here, or definitely from here, at 8 a.m. for another episode of Monday Morning with Mo. In the meantime, if you guys have any legal questions, you can always email us, askask@dewittlaw.com, or you can leave a voicemail, 407 536 6737. If something comes up during the week, we are open 24/7, 365. We have people answering the phones. And if you need me, they'll put you right through to my cell phone, even while I'm on vacation. So I hope you guys have a great week, a great morning, and we'll see you back here next Monday for another episode of Monday Morning with Mo. Take care, guys.